we have talked a lot about a will, but we have to do some fundamentals here. What property passes under a will? It's all the assets owned by the deceased at the date of death, owned personally. Now, if there's a trust that's been set up during his lifetime, those assets are governed by the trust document. So it's, if I die, well, if I die, nothing is governed by my will because my wife owns everything. So, or we have joint ownership of assets. So on my own, I think I own my car. That's about it. So that can exclude a lot of things. So, joint tenancy. Do you want to explain joint tenancy?
I will in a moment, but I'll just quickly go over property that's not governed by a will. So assets held as a joint tenant. As we said, assets held in a trust that I've set up during my life, meaning a living trust. We went over that. And then also beneficiary designation assets. So our RSPs, RIFs, TFSAs, and insurance death benefits. Those don't necessarily pass under my will. Okay, so types of joint ownership, there's two types. There's tenancy in common, and then there's joint tenancy. And they're quite different from one another. Often spouses own as joint tenants. If you own as a joint tenant, then that asset that you own in joint tenancy doesn't pass under your will. It automatically goes to the other joint tenant when you die, okay? So this is just kind of covered by this slide as well. Tenancy in common can be split up in any portion depending on what you've agreed upon, whereas tenancy in common is split equally between the joint tenants. And then, like I said, will pass to the remaining joint tenants on one of the joint tenants' death. Whereas tenancy in common, the portion that's owned by the person that dies passes under their estate. So this is an important distinction for that reason, really, when we're talking about estate planning. Is that clear? Okay. Joint accounts. True joint accounts. Versus joint accounts of convenience. So who owns the funds in the account? Banks don't usually address this. They just want to know who can withdraw the funds. So joint accounts can create problems if you're not clear about them. I'll let you talk about the legal presumptions of joint ownership.
As Laylee said, the bank doesn't care who owns the money. They just want to know who can withdraw the money. So if I have a joint account with my wife, we have two joint accounts. I put all my money in one joint account. That way she can write checks on that account, even though it's all my funds. She has a separate joint account where she puts all her money, and theoretically, if I could find a checkbook, I could write checks on that account. But so that is a joint account of convenience because it's just like giving a power of attorney to somebody so they can withdraw funds. Now, a lot of people will say, I'm going to put my house in joint tenancy with my children, or I'm going to put an investment account in joint tenancy with my children as a way of avoiding probate fees because then the assets will pass to the surviving joint tenant. But it's the last child alive will then get everything. Now, this has been the subject of a fair bit of litigation because it's never clear if I'm putting it into joint tenancy as a way of avoiding probate tax, because then it passes to the surviving joint tenant as a matter of legal principle. But really it's my money and I pay all the tax on the account and everybody understands that it's my money and I'll take it back and I'm the only one who can use the money, then that's not really a joint tenancy. Now the presumption, legal presumption is that people never give anything away. We will give something away to our minor children, and I'll give something to my spouse, and if I give something to my spouse, the presumption is that my spouse, that's a gift to my spouse. But if I give an asset and I put it into joint names with my adult children, the presumption is once they're 19, I don't want to give them any more gifts. the presumption is that I'm still the owner of that asset. So even though it's in joint names, the legal presumption is it's really my asset. So what that means is I've got to have a document that shows, or somebody's got to prove that I actually wanted them to have the asset. And that gets into, most of these family arrangements aren't documented. So there were a couple of cases that went to the Supreme Court of Canada. There's a presumption that joint tenancy is really simple, but 2 cases recently went all the way to the Supreme Court of Canada. Same facts, but 2 different results, because when you go to court, it's sometimes
the judge decides what's fair.
Yeah, and the judge
So don't
will
rely
say,
on presumptions.
the judge will say, well, this was important in this case,
Yeah.
but this factor was not that significant in this other case. So in the case of Bacour, aging father placed bulk of his assets into joint accounts with his daughter. So joint tenancy was the form of the account. Father continued to use and control the accounts, declared and paid all the taxes. The father's estate was to be divided between the daughter and her husband in his will. So the daughter and the husband divorced. The court said the joint accounts were not assets of the estate, and the daughter owned the joint assets because they didn't want to give anything to the husband. Because if you read the decision, you get the impression that the husband was a bit of a jerk, and the court really did not like him. At the same time, same day, in fact, the judgments came down together. Madsen Estate and Taylor, aging father, opened a joint account with his daughter, not with the other children. Only one daughter. There were other children. The will left his assets equally among the children. The father died. The daughter said, this was a joint account between me and Dad. This money is all mine. The court said, no, those are assets of the estate, and daughter, you were holding them as an agent of your father. Therefore, it's an estate asset. It gets split equally among all the children. So what you do is, if you are setting up a joint account, don't rely on legal presumptions, because who knows what evidence is going to be relevant. You think about who do you want to own the property, set up have a document that sets out the intention, and say, if I'm setting this up as a joint account and it's a real joint account and I want the other person to take it all, you say that in the document. So declaration of joint tenancy, I'm putting this into joint account. I know that the survivor of us will take everything, and that's what I intend. And you identify that specific asset. Now, the downside, everybody wants to put assets into joint accounts because you don't pay the probate tax of 1.4%. But people don't think about the dangers of having assets in joint account with the children. So let's say I put my house into joint account with my children.
Joint tenancy.
Joint tenancy.
Yeah.
Now, what I've done is I've sold part of my house to my kids. So let's say my children also have a house that they live in. So if I sell my private home, it's tax-free. So now I've got a 50% interest in my house. So I've sold 50% of my house to my children. That was tax-free because it was my house. But now I own only 50% of my house. The children own the other 50%. My child already has a house. So when I die, my principal residence exemption is half of the value of my house is tax-free, but the other half owned by my daughter, say. With that, when she actually sells the house, that's a capital gain of hers. She's already got a residence, so she has to choose. So in order to save the 1.4% probate tax, she's paying 22% on a capital gain on half the house. So I've sort of shot myself in the foot. Too smart for my own good. Let's say I put my house into joint tenancy with my son. And let's say he's a lawyer. And let's say he makes a mistake and he gets sued. So now the creditors, and let's say he didn't pay up his law society insurance premium, so he has to foot the bill himself. So the creditors come and say, okay, we've got a law, we've got a judgment against your son. Your son owns half your house. We want half the house, please. And you say, well, no, he doesn't. Well, it says at the land title office he owns half the house. He's a registered owner. We're taking half the house. So you do expose yourself to creditors of your children. And remember, you're older, you've got everything paid off, but your children are just starting out and they're taking financial risk, and they have to. You're at different stages in life. Well, let's say my son wasn't a lawyer, but his marriage didn't work out. Hey, he owns half your house. Now, that's a matrimonial asset. So it goes to the...
half of his half.
Yeah. Mm-hmm. And so there are downsides of placing assets into joint tenancy. Now, the joint tenancy craze is because people don't want to pay the probate tax of 1.4%. Now, most people don't understand about probate. There's no legal obligation. Now, when you die, your will gets probated. Why does your will get probated? There's no legal obligation to probate a will. But the problem is that you can change your will every day if you wanted to. If you thought that lawyers were a disadvantaged group and you thought, have to provide work for them, so I'm going to change my will every day. So let's say my father dies and I come to Laylee and I say, here's my will, or here's my father's will. And Laylee looks at it and she says, well, this will is 5 years old. He signed it 5 years ago. How do I know he didn't do a will 2 years ago? How do I know he didn't do a will 1 year ago? Well, nobody knows. The bank isn't going to know. So that's why you get probate. Because you go to court and the court says, okay, you have to send out notices. If anybody knows of a later will, they're supposed to pipe up and say that there's this other will. So if nobody says there's this other will, then the court says, okay, this is the last will and testament, and yes, he had capacity when he signed the will, so people can now rely on this will. So now the bank will say, okay, you've got a probated will, you're the executor, the court says that this is all right, so now we can let you have control of the funds. And that's why you get probate. Now, if nobody asks for probate, you don't have to get it, but the bank's going to ask because they don't want to give the money to the wrong person.
The land title office is going to ask.
Land title office, if you have a house, they'll require probate because they don't want to put the property in the name of the wrong executor. They need to know that this is the last will. Why would you want to avoid probate?
Well, because there's probate tax, as we mentioned, which is 1.4%. Also, when you probate a will, it becomes a public document. So I don't think there's a lot of people necessarily going and reading everybody's will that's gone through probate, but there's a bit of a loss of privacy there.
Yeah.
And then there's a delay in dealing with the assets, of course, because it takes time for things to go through the court. I would say usually it's about 8 weeks at best. So there's a delay there, and so on and so forth. So as we said, 1.4% of the estate, there's just some numbers for you, and there's no exemption for principal residences from probate tax. There's an exemption from capital gains tax, but there's still that probate tax that has to be paid, just so that you're aware of that when we talk about the principal residence exemption. So ways to avoid probate, joint tenancy, as we talked about, there's dangers to that, but it is a way to avoid probate. You can hold assets in a living trust because then they're not assets of the estate, as we've talked about. When I decide I want to give that property to Blair, it's no longer mine. You can have a separate will for assets that might not need to pass through probate. So as Blair mentioned, certain assets you're going to expect, for example, real estate, the land title office is going to require probate. They're going to require a court-certified grant of probate. Banks are going to require probate. But if one of the things that you own is shares in a private corporation, nobody's going to require probate for that. So you can hold those assets in a separate will that doesn't have to go through probate, and then there's going to be no probate tax on those assets. Okay, living trusts, remember these? There's a disposition when you make a transfer into a living trust. So that deemed disposition that we talked about that happens on death, and there's a deemed disposition that happens every 21 years with trusts. There's also a disposition that happens, it's not actually deemed. But when you transfer assets to a living trust, it's like you sold them. So there's tax to pay. But there are certain times that you can transfer assets to a trust and not pay tax.
Yeah. You can transfer assets to an alter ego trust. So if I'm over 65, then I can transfer two assets to a trust of which I'm the only beneficiary during my lifetime. On my death, other people take as beneficiaries, and then I can, if the assets are held inside that trust, I don't pay probate tax. Now, I still pay the capital gains tax on my death, but it just avoids the probate tax. So if that makes sense, you could do that. A joint spousal trust is, again, I have to be over 65 when I set it up, but I can have the assets held in that trust for the benefit of me and my spouse during our lifetimes. If my spouse survives me, she's the only beneficiary until her death. And then on her death, other people can take beneficial interests in that trust. So that's a way of avoiding probate. But if I do that, those assets can't be part of a qualified disability trust because that trust is set up during my lifetime because it's set up before I die. So if I do that, those assets can't go into a qualified disability trust because the trust is already set up on my death, prior to my death. You can have a trust to hold your principal residence. Don't do that. Because
you can, but don't.
You can, but you have to be very careful because it can mess up the principal residence exemptions that are claimable by your children, because one principal residence exemption per family for capital gains tax purposes, if the house is owned by a trust, the beneficiaries of the trust are the family. So if the trust claims the principal residence exemption on the house, any of your children who are also beneficiaries of that trust can, you can result in them losing the principal residence exemption on their houses.
So just to be aware of. These are just things to be aware of. You don't need to memorize any of this.
Don't need to memorize it.